name is Siti Aisyah binti Muhammad. My ID number is 2020873686.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Syafiqah Aryani binti Mat Daud. My student ID is 2020469668.
Hi, Assalamualaikum. My name is Siti Aisyah binti Sarapah and my metric number is 20208668. First of all, I'm gonna present to you about the introduction. Judicial independence has become an exit to justice and equality in every country, including Malaysia. Therefore, a judge must be fair and just in making any judgment and making any decision. Judges should not be influenced by the executive or the body in making judgments. As a judge, he must not be influenced or favored by any party and must carry out his duty with security. The judiciary must have the freedom to act as an institution. The judiciary is a body of judges in a constitution system. In terms of power and rules, there is a judiciary that varies between one country and another. This power is enshrined in the Federal Constitution of Malaysia. This body is also known as the legal system, and its members consist of judges and magistrates who are usually appointed by the respective heads of state. Next is about the background of the judiciary. The Judicial Appointment Commission was established with the enactment of the Judicial Appointment Commission Act 2009, Act 695 Gazettes on 8 January 2009. The establishment of the commission is an initiative strengthen and enhance the integrity of the judiciary through nomination, selection, appointment, and promotion. Since its inception, the commission has successfully discharged its responsibilities as an independent judicial appointing body with the Constitution all framework. In addition, the Commission has the role of receiving and considering application from qualified persons to the post of Supreme Court judges based on the provision of Section 21 of Act 695. Various programs have been implemented by the Commission to add good justice system in the judiciary, including holding training programs for Supreme Court judges, as well as publishing judicial journals. The Commission is composed of 9 members, including the chairman. The membership of the Commission is based on the provision prescribed under Act 695. The members of the Commission are appointed by the Prime Minister after consultation with the Malaysian Bar Council, the Sabah Law Association, the Sarawak Bar Association, and the Federal Attorney General. The structure of the Malaysian judiciary can be divided into 2 parts, namely the Superior Court and the Subordinate Court. The highest court in Malaysia is the Federal Court, followed by the Court of Appeal, the highest court of Malaya, and the High Court of Sabah and Sarawak. The Session Courts, the Magistrates Court, and the Court for Children. The subordinate court consists of a session court and a magistrate court. The special court was established by the Federal Constitution on 20 March 1993 and has jurisdiction to hear civil or criminal action initiated by or against His Majesty the Yang di-Pertuan Agong or other Malay rulers.
Now, I will present about the role of the judiciary. The judiciary has to perform judicial duties, and its power rests with the High Court and the Subordinate Court. These bodies serve as a protector of human rights from violation by government or individuals, as enshrined in Article 126, 128, and 130 of the Federal Constitution. Judicial power also rests with the Supreme Court. Next, the judiciary has the power to hear and determine criminal and civil matters. Criminal matters involve the penal code, while civil matters are related to a suit and usually require an affidavit. In addition, the judiciary also has the power to interpret the federal constitution and the state constitution. The judiciary can also determine the validity of laws made by the governing body and the legislature. A court that declares a written law for the state government for the federal government. For illegal government action, only the judiciary has the power to declare them. The court have absolutely no power to amend the law, as the matter is the power of the legislature or parliament.
The first importance of the independence of the judiciary is to resolve any dispute. The independence of the judiciary is necessary to resolve any dispute because alternative dispute resolution methods are the methods that can be used by any party involved to resolve their problems, dispute without the need for court proceeding. The most common forms of alternative dispute resolution are mediation and arbitration. Based on Practice Direction Number 5 of 2010 issued by the Chief Justice on 16 August 2010, the courts, especially civils, are now given an appropriate framework to explore other alternative dispute resolution methods before proceeding to the trial process in court, including Islamic banking cases. The advantage of resolving such a dispute is, by the way, this party are able to explore all available options. The second is the basic issue and points of similarity that can be identified. The third is good relations are restored and maintained. The fourth is conditions that have been agreed will be accepted by both parties. The fifth is the settlement is beneficial. The sixth is there is no delay in the court hearing, and the seventh is that all decisions are final. As such, dispute resolution is no longer focused only on the trial process in court, and even a handful of parties have started resolving their disputes through alternative dispute resolution methods. So, society should understand the advantage in resolving dispute through this alternative dispute resolution method. The second important is required to make decision or impose sentences. All parties must accept and respect the decision made by the court in every country, including Malaysia. Of course, all decisions made are based on the provisions of the law that has long existed in our country, which has been drafted in accordance with the Federal Constitution. This followed the decision of the recent High Court case involving former Prime Minister Datuk Seri Muhammad Najib Tun Abdul Razak, who was found guilty of 7 charges, including abuse of power, breach of trust, and money laundering. Judge Muhammad Nazlan Muhammad Ghazali made the decision after finding that the defense had failed to raise reasonable doubts about all the charges. After reading his judgment for 2 hours, the charges were made under the Malaysian Anti-Corruption Commission (MACC) Act 2009, the Penal Code, and the Money Laundering, Anti-Terrorism Financing and Proceeds from Illegal Activities Act 2001. The decision made by the High Court involved has begun to receive various reactions from various parties, both from within the country and from abroad, because the case involved one of the important individuals in our country. Whatever the reaction given, it is important for all parties to remain calm and respect the decision made by the court to continue to ensure stability and public confidence in the country's legal and judicial institution. Of course, any decision made by the courts in our country is based on the evidence and testimony that has been given during a trial. This is also supported by all the submissions that have been made by lawyers who are expert in their respective fields in a trial case. The criminal procedure code for the criminal procedure code are better known as Act 593 is a legal provisions that is the main guide, especially in criminal cases in our country, to bring offenders to justice. The criminal legal procedure will start from the reporting of a criminal incident to the police, investigation and trial process in court until the perpetrators are punished accordingly for their actions. Although the number of cases brought to court is increasing day by day, but not all these cases will end in conviction. The accused is likely to be convicted of the offense and receive the punishment prescribed by the law in our country. There are also cases where the accused will be acquitted because there is not enough relevant and convincing evidence to achieve the standard or level of proof required in a case. In legal terms, there are only two standards or levels of proof, namely beyond a reasonable doubt for a criminal cases, while it is beyond the balance of probabilities for civil cases. If the party who has been found guilty is not satisfied with the decision that has been set, the law of our country also allows them to make an appeal process at the next court level. In our country, any party who wants to submit an appeal can appeal to the Court of Appeal up to the Federal Court, which is the highest court in our country.
Okay, I will continue with the challenges in the independence of the judiciary. The first challenges is in gain public trust in the authority of the judiciary. To gain public trust in the judicial system is increasingly challenged when the issue of criticism arises. However, Chief Justice Tun Muhammad Rauf Syarif stressed that the public criticism of the court's judgment must be done constructively and with the respect and good intentions. Every citizen does have the right under the Constitution to challenge and test the propriety of a judge through due process. This system of judgment is open to criticism by the public. Malaysians have their own right to comment in court judgment. Through this, the judge will certainly not be exempt from making mistakes and should be open to criticism. Yet harsh and unfounded criticism threatens the foundations of the rule of law and weakens the judiciary in carrying out its responsibility under the Constitution. However, the judicial system is self-correcting and a person who is dissatisfied with the court's decision can use the next channel through the appeal process. The judiciary reaffirms with its commitment to the mission to maintain an independent and efficient judicial system that upholds the principle of the rule of law, protects the rights and freedoms of judicial and earns the trust of the local and international community. The second challenges is challenges in updating of policies, law and regulation in line with the passage of time. The judiciary needs to strive to develop a strong organizational capacity in meeting the post-2020 challenges through the creation of a flexible organizational system and efficient and effective human resources management. The judiciary also needs to strengthen professionalism, among its officers through the development of an effective training system that covers all needs in the service of the department. In this regard, the judiciary needs to take steps to streamline the best governance to ensure that all the needs of the department in terms of finance and human resources are governed by the appreciation of values based on best governance such as prudence and objective spending and compliance with the regulation set by the government. The post-2020 years is a profound need in the development of digital management of the judiciary and Sharia law in line with the current technology secularization. The judiciary needs to continue its effort to act as a leader in the digitization of Sharia code through high-impact digitization development programs. Through the development of this digitization program, the judiciary can perform its function effectively, especially to create a uniform and respective Sharia, judicial and legal service. The latest technology adapted in the digitization project can enhance the efficiency and management of the department's key data to be maintained and managed professionally and effectively.
Now, I will explain steps to overcome the challenges. The first one is be fair to all citizens in gaining trust. Every judge must remain independent in deciding a case without fear or favor and without any pressure from any internal or external party. The Chief Justice Tun Tengku Maimun Tuan Mat, on the other hand, state that the people's trust and confidence in the judiciary has to provide fair justice is the foundation of the judiciary. Tengku Maimun presented letters of appointment to 9 judicial commissioners and saw 5 High Court judges take the oath of office as Court of Appeal judges. Therefore, the judge also has the right to question the witness for clarification while testifying but cannot conduct a primary examination and cross-examine the witness to the point of exaggeration. He also stressed that in performing judicial duties, judges do not have the privilege of selecting cases. In addition, judges have full freedom to decide cases according to law and facts that, as well as judges are also responsible for upholding the integrity and independence of the judiciary. The value of integrity is not only the ability to reject corruption, but also fully respect the core values of freedom, fairness, personal integrity, decency, justice, efficiency, and diligence. The second step is straighten the law. With the passage of time and rapid advancement of technology, society now desperately needs a flexible and fair legal system that can recognize the diversity of problems and protect the interests of all citizens. According to the concept of cultural relativism, sociocultural and religious factors, it plays as a role in determining the type of legislation that exists in Malaysia. History has shown that harmonization of laws has long been done in Malaysia. In fact, it is applied in other countries around the world. Legislative harmonization is another national goal that is being pursued. The administration has taken several steps in the direction of legislative harmonization. Thus, the judiciary exhibits a similar trend with the topic of the establishment of the Malaysian common law. It became the main topic of discussion. The Malaysia common law in question is the result of a process of legal harmonization and not the ordinary course of directly absorbed law. The harmonization of Sharia and common law for example, has helped in the information of the national judicial system, which is in line with the spirit of the federal constitution. Taking into current global events, Malaysia will continue to face various legal issues in the future. Legal dispute, crisis of trust in the legal system, and many other topics are bound to occur and are discussed by legal practitioners and many more. To resolve this issue wisely, the strengthening of this law is seen as one of the most strategic steps that can be achieved by taking into all factors, recognizing diversity, and protecting the general public.
The hope that the people need apart from the advancement of technology and physical infrastructure is that what is most important is human resources. Every member of the judiciary must possess a quality of integrity and competence while always keeping in mind that as judges, we do not side with anyone except the law. Without these key features, justice will not be achieved and we will fail in discharging our responsibilities. Therefore, I reiterate the judiciary's commitment to administer justice according to the law without fear or favor. The decision of the court is based on what is stated by the law and the evidence proof, and there is no place in court for any suspicion, bias, or favoritism. Judges and all judicial officers are free to apply the law without regard to the wishes of any group or public opinion. Such is the position of the institution of independence of the judiciary as the holder and executor of the trust of justice. The integrity of the credibility of this institution will threaten a crisis of confidence, which means great catastrophe for the people and the country. There will be no more peace and security. At any time, the good name, dignity, and honor of the country can be tarnished, and human rights can be violated. The Constitution has enshrined fundamental rights such as freedom of speech, freedom of assembly, and association. All these rights should only be a mere delusion if only proclaimed without enforcement. This right to liberty becomes meaningless if the court is subject to executive orders, so an independent judiciary is essential in playing a role in upholding justice. Judges in Malaysia are reminded that the Constitution is the highest law in the country, and any law passed that is inconsistent with the Constitution should be declared invalid. It is very important for the judiciary to be free from political and other influences. Judges should have the courage to oppose such interference and the courage to tell the executive not to interfere with the functioning of the judiciary. Judges must enslave themselves to the law, not to individual. So, in my opinion, the independence of the national judiciary in a parliamentary democracy in Malaysia is something I strongly agree with and support this matter 100%. This is because it is independent of anybody, meaning justice in Malaysia can be upheld as possible without the influence of anybody to ensure the progress and harmony of the country for now and forever.